Hi everybody. To facilitate seamless trade-related payments and regulate forex transactions, the government introduced the Foreign Exchange Management Act (FEMA) in 1999, replacing the Foreign Exchange Regulation Act (FERA) of 1973. Since the older act was not considered to be in sync with the post-liberalization market realities of the country. That was a period when the country was still experimenting with a new economic direction under its focused implementation of liberalization, privatization, and globalization, the famous LPG model. Thus, there was an acute need for an act to regulate foreign trade-related payments. Today, the FEMA Act not only governs foreign exchange transactions and remittances but also provides a robust framework for the functioning of cross-border trade. Cross-border trade, both in the form of goods as well as in services, is increasingly being facilitated via e-commerce, and that's also one segment where provisions of FEMA regulation apply. So what are the common mistakes exporting firms should avoid while dealing with FEMA regulation? Exporters must ensure that the amount representing the full export value of the goods exported is received through an AD, authorized dealer bank, within 9 months of the said export. For exports that involve third-party payments are supported with the necessary documentation such as tripartite agreements between the buyer, seller and third party. All filings are duly reported on the Export Data Processing and Monitoring System through the AD bank. Such filings must be consistent with the data provided in the Bill of Entry. Exporters and traders do not ignore compliances at customs port. Exporters are also advised to not ignore reminders from authorized dealer banks to clear outstanding export payments. A failure to do so could invite action from the RBI. RBI Master Directions on Exports provide that an exporter entity can be caution listed if any shipping bill against it remains open for more than 2 years in the Export Data Processing and Monitoring System, provided no extension is granted by the AD bank or the RBI. Further, the date of shipment will be considered to calculate the realization period. The exporter entities can also be caution listed before the expiry of the 2 years based on the recommendation of the AD bank concerned. The recommendation may be based on cases where the exporter has come to the adverse notice of Enforcement Directorate's Central Bureau of Investigation, Directorate General of Revenue Intelligence, or any other law enforcement agency, or the exporter is not traceable or not making any serious efforts for realization of export proceeds. If exporters expect a situation where they may not get the proceeds in due time, they need to immediately contact their AD bank to seek an extension of up to 6 months. This is needed to realize outstanding export dues. It is equally important to not accept goods at the port without necessary inspection. Once the goods are accepted, it may be difficult to refuse payment on the grounds of inadequate quality. For consultancy services related to fundraising, GST, taxation and ancillary matters, feel free to reach out to us on our coordinates below. For more such informative content, follow us on YouTube, Instagram and LinkedIn. Thank you.